Yes, my closing point relates to LEFRA and the influence, if any, that it has on the retrospectivity debate. If I could go, please, to Bennion, which is in the authorities bundle, the core authorities bundle, tab 15. You'll recall this is the supplement,
yes.
Which has been added subsequently, and it's page 423, section 24.19 of the book. Before we go to the Act itself, this is setting out the test. So the first proposition is the legal meaning of the enactment has to be doubtful, then sufficient legislation may be relied on as persuasive authority. So there's a gateway of doubt. And then in the comment section on the following page, one can see that where it appears, I'm reading from the top, that an enactment, that being the later one, proceeds on a particular view of an earlier act, the question may arise as to whether this may be relied upon. And then just below the quotation from IRC, where, however, the legal meaning of an enactment is doubtful, a later act may be treated as of persuasive authority if it indicates that the legislature took a particular view of the existing law. And then a quote from Master of the Rolls, Lord Sterndale in Cape, where he refers to the earlier act having been ambiguous. And then I rely on the passage, particularly above the heading example. The courts have consistently repeated the need for ambiguity before reliance may be placed on later legislation. Ambiguity is here used to mean the earlier provision must be open to two perfectly clear and plain constructions, or fairly and equally open to diverse meanings. This test is a high one. It's not enough to show simply that there are more than one arguable construction. They must be both equally tenable. And in that context, the cases that are cited are footnote 6A and 88, or 8, I think it's 88. That's open spaces is one of them, which we referred to, and that's at tab 19. I'm not going to take you, your lordships, to it. There's two cases. There's DSG Retail at tab 17, and open spaces at tab 19, both of which look at the threshold of ambiguity in the extent to which it must be properly ambiguous. And you have my point. The view, leaving aside the linguistic words themselves, viewed in context, which is the exercise one needs to go through before coming to the view of ambiguity, we say these words are not ambiguous, which was the conclusion that the FTT reached. So that's the gateway, so to speak. The second point is, even if it were ambiguous, LEFRA does not show that the legislature took a particular view of the existing law, which, as you have seen, was the proposition which is relevant, or has to be relevant here. And for these purposes, can we go to LEFRA, which is at tab 2. Sorry, is at tab 2. Sorry. It's in the triathlon. Yes, apologies. Tab 2. And we have to look at section 116 and what it's seeking to do here. And Melanford took you to this in opening, where you remember when it was inserted into section 124, one could see what it was seeking to do. It included, in subsection 2, a broadening of recoverable costs within scope, namely costs not just remedying, but costs otherwise in connection with. So broadening of the connecting piece, if I can put it that way. And then more specifically a new subsection 2A, which broadened expressly broadened the identifiable but non-exhaustive list of costs. Just to give an example of, or examples of those, subsection B, you could now get a remediation contribution order for costs of procuring an expert report, so that the leaseholders or whoever aren't disencouraged from getting the evidence necessary to demonstrate what needs to be done to the building. And similarly, insofar as the execution of works needs the tenants, the leaseholders, to move out, temporary accommodation costs are included in subsection C. And obviously, if one was focusing exclusively under the old regime on cost of remedying, it might have been said with some force that alternative accommodation might fall outside that. So there's the footprint of costs that may be within the ambit of a Section 124 order are broadened by Section 116. But the submission that I make in the present context is that it doesn't shed any light of the legislature taking a particular view, because the words incurred or to be incurred are the same. And that remains the threshold in each of the examples of subparagraph 2A. Costs incurred or to be incurred in taking relevant steps. Costs incurred or to be incurred in obtaining an expert report. Temporary accommodation costs incurred or to be incurred. So it's absolutely neutral on the meaning of that expression. That's my second submission. Then when it comes to...
Or consistent.
Yes, consistent.
Which is perhaps not surprising.
Perhaps not surprising, I might add, having this legislation having been passed post the decision in Triathlon. The passage, the section that my learned friend relies on is subsection 7 on page 12 of the bundle, which your lordships have already seen. And my learned friend relied on that for the proposition that Parliament does not legislate in vain. And our submission, as we put in writing, is there was absolutely a purpose to subsection 7b, namely to clarify that no temporal distinction will be drawn between those costs falling within the original section 124 and those costs falling within the new ambit of section 124. So everything, whatever it meant, everything was now on an equal footing, whether it was a pure cost of remedial work or the cost of temporary accommodation. It was, of course, therefore, existing. This was now amending an existing piece of legislation, just as Section 135 was amending the existing DPA. So the provision was needed to explain that the effect takes you back, so to speak, to the law as it stood in 28th of June 2022, whatever that may be. And so we say it's entirely consistent with our position. It certainly does not suggest that Parliament took the view that the law needed to be changed or whatever. And in any event, we contrast, and this is really my final point, we contrast that provision with section 117, which is the next page, which is recovery of legal costs through the service charge, which the detail of which I'm not going to go into. But subsection 4 of that amendment says in terms that the amendment does not apply in relation to legal or other costs provided before the section comes into force. My learned friend says, oh, well, that's a different provision. But I say that there, the law is, the Parliament is expressly deciding whether to make a provision prospective, and doing so. See, by contrast, Section 166 and the approach that it takes in relation to that. So we say, Your Lordships can derive some support also from Section 117 and the way it treats the question of retrospectivity. So that is really all I wanted to say on retrospectivity. It's I acknowledge there's a presumption, but the presumption is applied in circumstances of a sliding scale. This retrospectivity is at the far end. It's simply relating to a package of facts that occurred, namely the incurring of costs in relation to relevant defects going back 30 years. That's not retrospective legislation in the sense, to take the other extreme, of giving you a right and treating you as having had it for 10 years at the other end. And the degree of unfairness is entirely catered for by the breadth of Section 124 itself. Unless I can assist further.
Okay. Thank you very much, Mr. Nissen. Mr. Polly.
My Lord, we would adopt pretty much everything that Mr. Nissen has said. It accords with our skilly. But we have our own voice, if I put it that way, as the management company that has a very substantial responsibility for the maintenance and repair of these buildings. Without repeating what Mr. Nissen said, I'm going to try and ensure that voice is heard from the perspective of EVML. So what I'm going to do, if I may, is I'm going to start by just making some submissions about the title structure. There were some questions short this morning about the title structure, and it's just worth me closing those off so we all agree precisely where we are. I'm going to talk for a little bit about EVML as an estate management company, because although it's a landlord, it is an estate management company, and it has this, what I'm putting it as a fragile sort of hand-to-mouth existence. But that is, I'm going to talk a little bit about the experience of the FTT, because there are some comments that have been made there, and I feel that I can usefully contribute to those. I'm going to talk for a little bit about the policy of the Act. I mean, I have formed the impression that everyone sort of agrees now what the policy is, and we have a handle on that. But there are some points that I haven't noted anyone else making, therefore I would like to make them. I'm going to fly through grounds 1 to 8 and 1.1 to 1.8 and 1.10. I'm going to linger on 1.9. And then I'm going to make some brief observations about ground 2, which, certainly in the context of this appeal, doesn't really affect EVML because of the way the figures work and so on. But has the potential to affect EVML, and so I'm just going to make some observations in that regard. If I may start with the title structure. So we have the chart. I think you've already been taken to it. It's behind the supplemental bundle, tab 4, page 17. And this is covered at paragraph 5 of my skeleton argument, which is in the core bundle, page 82. So sitting at the top, we have Stratford Village Property Holdings 1 and Stratford Village Property Holdings 2. They are the freeholders. You can see, because the dates are given, that the superior leaseholder, EVML, was sort of inserted afterwards. Taking it chronologically, the freeholder demised the head leases, firstly to Triathlon Homes.
Do we know when the two trustee companies acquired the freehold?
I'm sure we can find. I mean, it will be on the.
Because it was presumably vested in what, the Olympic Delivery Authority at one stage, or...
I think it was part of the way that the property was held as part of the Olympic development. I will make sure that's bottomed out.
But before you came on the scene?
Before we came on the scene, yes. Each of the leases, as you can see in the skeleton argument, dealing first with the Triathlon Homes LLP head leases, each of those is of several dwellings.
It's what, sorry?
Several dwellings. It's
Yes, I see. Yep.
Groups of properties.
Yes.
And what Triathlon has then done is subdimise them, and shared ownership leases, AST type leases, various types of lease. EVML is the estate management company in the Triathlon Homes head lease and in each of the individual subleases. And pursuant to that status as management company, has primary responsibility for the maintenance of the buildings. I don't think anyone has ever suggested that that doesn't include the remediation of the sort of defects that we're talking about here. It's a similar arrangement on the QDD, or get living, side of the leasehold structure, in the sense that the QDD head lease, the one to EVN26 Limited, each granted several dwellings, and EVML was the estate management company in relation to those. QDD then subdivided individual leases to get living EV and EV26 Limited, and in each of those individual leases, EVML is the estate management company. And then Get Living's business being renting out property at rack rates on ASTs. That's what it does. And after all those leases were demised, EVML then took a head lease. So it's inserted in. So the point that we then make is that, you know, EVML, we're concerned with 5 buildings in this case, but in fact, this type of structure is replicated across several places of the East Village. You've seen the updating note referring to other buildings. There are 63 blocks for which EVML is responsible, of which these are just 5. And EVML wants to get on with this remediation work. This is not something, if there's been, I heard my learned friend talk about EVML dragging its feet. Certainly, whilst there might have been boardroom disagreements, I don't think there was any fundamental disagreement that something needed to be done and EVML had to do it. The problem, inevitably, is how it was going to be funded. Because as an estate management company, it has no real income. It doesn't trade like Triathlon or Get Living do. It receives service charges, and it pays its overheads, and it manages the estate. That's its purpose. That's what it does.
It doesn't get any ground rents? Peppercorns?
Well, peppercorns, yes. It's you know, there's nothing... Yeah, nothing substantive.
Peppercorns of themselves are not much help.
Quite. And you know, everyone agrees that paragraph 2 of Schedule 8 applies here. So the normal way this would work is EVML sees a need to do something. It raises a service charge in advance by way of an estimated service charge. It does the work, it accounts for it. There's either a surplus or a shortfall. That's accounted for, and the surplus, if there is one, is dealt with in accordance with the lease. And if there's a shortfall, there's a provision for a sort of a balancing payment. None of that can apply here.
Sorry, can you just talk me through that? Paragraph 2 of Schedule 8 prevents service charges being claimed by a responsible landlord.
Well, yes. I mean, it's worth looking at it because we've all made the point, I think, in our skeleton argument that it is the most dramatic of the leaseholder interventions. Because paragraph 2 of Schedule 8 applies, is the developer condition, and that is it's at the core authorities bundle at page 68. And it applies when, if there's a relevant landlord, and we know what that means because it's defined at the bottom, the landlord under the qualifying lease, or under the lease at the qualifying time, or anyone above. So if anyone, if as the tenant you are looking up at the title structure above you, if any of those is responsible for the relevant defect, or is associated with responsible for a relevant defect, no service charge is payable under the lease.
So it's the trustees who are associated with SVDP? The freeholders?
Yes. Well, that's a slightly different question. So there's an issue about the association with SVDP. Certainly, the member companies are associated with SVDP because Section 121 says so. Association is slightly different. I mean, we can come on to association in a minute, although you have to bear in mind that I wasn't at the FTT hearing, and you've heard from my learned friend, Mr. Nissen, about the concession that was made and the sort of the understanding that was reached that it didn't matter whether there was an association with SVDP or not. So there are a couple of points that we make about this. So the first is if anyone above you in the title structure is responsible for the relevant defect or is associated with someone responsible for the relevant defect, then, and this is worth noting, no service charge is payable. Now, just flick over the page to page 70, paragraph 4 of Schedule 8. It's a different provision. But no service charge is payable under a qualifying lease. Under Regulation 5 at page 71, under a qualifying lease. Now, the distinction about paragraph 2 of Schedule 8 is that where there is someone above you in the title responsible for the relevant defect or associated with a person responsible for the relevant defect, no one pays a service charge. No one sort of underneath that position in the title. So the qualifying tenant doesn't pay a service charge, and the tenant above the qualifying tenant doesn't pay a service charge, and the tenant above that doesn't pay a service charge until you get to the point where you've hit the point in the title structure where the landlord is the landlord who's responsible for the defect. So if we go if we look at this, and this might be the question that
So if a relevant landlord, the words which appear at the end of subparagraph 2,
yes,
is responsible. etc., or is associated, etc.
Yes.
If a relevant land,
Yes.
so it doesn't have to be,
It doesn't have to be your immediate land.
yes,
You're just looking up at the title structure above you. And if any of them are associated, so yes, to come to the point, we say that if you look at the way that the properties are owned.
well, in fact, I'm just going down to the bottom. Relevant landlord means the landlord under the lease at the qualifying time, or any superior.
Or any superior landlord.
at that time,
It's
which
the
is why it
idea that.
says A.
Yes.
And the qualifying time is 14th of February.
Yes. So you look up and you find someone who can be said to be responsible for, and no one until you hit that point in the leasehold title structure has to pay a service charge.
So not only does Triathlon not have to pay, but nor does QDD, nor Get Living, etc.
So
nor the
if we go back to the title structure, none of these have to pay a service charge. And that puts EVML in a really difficult position.
Sorry to be stupid. Is that because EVML is associated with a person responsible?
Well, there's an argument about that too. But it's because no one has to pay a service charge.
But who is the relevant landlord? Who is associated? In
Well,
our
you
case?
start, it's certainly SVPH1 and SVPH2.
Right.
And because they hold on trust for SVDP, which is the developer.
And that makes them associated.
And that makes them, I mean, we can look at section 121, but as I understand it, that's not in dispute. Now, sometimes I worry that, you know, I'm being a bit basic in what I'm submitting, but a sort of an understanding of the way this works and where that leaves a company like EVML is really important. And just with an eye on the fact that there will be lots of people across the country interested in the outcome of this case, that is not unusual. It is not unusual for an estate management company to basically have no substantial income other than its service charges and responsibilities that it can only meet from its service charges. And so when you have a provision that says you can't, no one pays a service charge in this case, that creates a bit of a problem. And I would, if I may, just touch on some of the submissions that you've heard about whether there's a good reason for making this application or not, or so on. There were some submissions this morning referring to the chronology, and just to make a couple of further points in respect of that, if you are the director of a company like EVML, you cannot sign up to something like the Errigal contract, 27 million pounds, without satisfying yourself that you have the funding secured. I mean, that would be financial suicide to do so, or extremely reckless, unless you were happy that you were in a position where the funding was secured. You've heard some, I think you've been taken to the chronology, you've heard some submissions about what happened when. You've heard that the pre-tender support was made available on 19th of October 22. I'm not sure you have been taken to paragraph 201 of the judgment, which is at page 188 of the core bundle. If you have, I apologise, but it's
Sorry, which paragraph?
It's paragraph 201 at page 188. So you can see the parties are sort of inching towards, in my submission, a position whereby there's increasing comfort, if not certainty, that funding is going to come.
But you also get a flavour of the differences in the stances taken in paragraph 200, the previous paragraph.
Yes. Yes, I mean you can see it. It's difficult, right? On the board of EVML, you've got Get Living and Triathlon directors, as my learned friend summarised, but that's fairly accurate. You've got Get Living with a casting vote. We've got Triathlon saying, well, paragraph 2 applies. It can't be done by service charge. Well, how is it going to be done? It's fair to say that we had pre-tender support at this stage. You've been taken to the agreement in relation to that already, but just to sort of cover that off, it's in the supplemental bundle, section E, tab 1, and I'm going to refer to clause 5.7, which is at page 176.
Sorry, 5.
It's 5.7, page 176.
Thank you.
And it says expressly that just because we've given you pre-tender support, it does not mean you're going to get full funding.
Do we need to understand the difference between the roles of the GLA and the department?
So, as I understand it, the department provides the money and the GLA administers the fund within London on behalf of the department.
Thank you.
I'm sure I'll be corrected if I'm told that's right. And this goes, in my submission, to my learned friend Mr. Selby's submissions about, well, there's no point for this application. It's all clean. The funding was there. It's certainly at the point when the RCO was made, that's not true. That's not a fair submission. Sorry, when the RCO application was made, that's not a fair submission. The submission that might be a fair one, I say it's wrong, and for reasons I'll explain, but that might be a fair one, is once the funding was in place, you should have abandoned the RCO. And I say that's wrong. I say that's wrong for the general reason. I've made the point about the fragile hand-to-mouth existence, and therefore it's important for a company like EVML to have multiple sort of strings of funding. And that leads to an important point that needs to be kept in mind when we look at the RCOs. If we go to the core bundle tab 12, page 211, this is the RCO, this is paragraph 4. And this is the paragraph 4 is the paragraph that round 1 is principally concerned with. And the passage I would like to draw your attention to is the bit in the middle. And Triathlon's share of such further or other reasonable amounts, sorry, I'm reading 4 lines down, 3 to 4 lines down in paragraph B, as are incurred by EVML in completing the said works to each of the blocks. And there's a similar rubric in C from the 4th line onwards. And what this means is that the RCO entitles EVML to receive the specified sums, being Triathlon's share of the cost of the major works. At that stage, the entirety of the cost of the major works being BSF funded, together with any further funding. So it goes beyond, these RCOs go beyond, as it were, the recovery of BSF funding, they entitle EVML to be put in funds for further monies that were not then confirmed by the BSF, and we know from the updating note have not now been confirmed by the BSF. So the point that I made at a fairly high level of generality, which is, well, for a company like EVML, as many sources of income is a good thing. It's a prudent thing to do. Just because you have BSF funding, you don't pull the RCO application. I say it has been made good by the way that by the RCO that was in fact made, and by the way the facts have turned out. So if this appeal fails, those paragraphs 4B and C, and those particular, the words that I've drawn your Lordship's attention to, will be how EVML will try and fund its shortfall. I'm not for a second going to make the submission that it's going to be agreed and everything will be fine. I'm sure there will be all sorts of inquiries about, well, why was this denied by the BSF and what are these costs and so on and so on and so on. But that's...
And they're only reasonable amounts anyway, which enables you to argue up and down there.
Quite. But it is at least a sort of a route, well, to solvency. Now, it's only fair when I make this submission that I also draw to the court's attention that the tribunal found that the works wouldn't be threatened by lack of funding, and I think you've been taken to that already. But this isn't really about the threatening of the works, because you know from the updating note that the works are almost completed anyway. The works aren't going to stop now because of this shortfall. The problem is the problem from EVML, because it leads this fragile existence. And in my submission, that touches upon some other submissions that I think were made yesterday afternoon by my learned friend, Mr. Nissen, about the expertise of the FTT and how, you know, this is a statutory scheme entrusted to the tribunal system, and we really ought to leave them to get on with it. And he came up with some examples of where the FTT or the Upper Tribunal, in the case of restrictive covenants, would deal with developers. In my submission, that rather undersells the experience of the FTT, because it is not at all uncommon for a Section 27A application concerning the reasonableness of service charges to be concerned with extremely expensive works, capex works, to be concerned with issues about whether this product should have been used or that product should have been used, or whether a whole scheme should have been rejected in favour of another whole scheme method of doing the work. Whether the scheme is fine but the costs are just too high. These are highly technical issues, but they are the bread and butter of FTTs up and down the country. So there's nothing remarkable about entrusting these sorts of questions to an FTT. So those are sort of my preliminary submissions about the structure of EVML as a party and how it sort of fits into this case. I'd like to make, if I may now, a few submissions about the policy of the Act. And maybe this is such an obvious point, and that's the reason that I don't think anyone else has said it yet. But there's been lots of discussion about the policy of the Act being to remediate buildings and to protect tenants. In my submission, it is also the policy of the Act to sort out who pays. Because someone has to pay. And if you are going to say as a parliament that the usual way for someone to be made to pay via the service charge is just not going to be available, you know, Parliament will have said that in contemplation that someone else will pay. So it is the policy of the Act that the losses lie where the statutory scheme leaves them lying. And that's important in my submission, because we all seem to agree that it's developers at the top of the hierarchy, and I suspect I don't need to make good that submission, but I will just make it very, very few comments in that regard. And that means it's the policy of the Act that developers are at the top of the hierarchy. Because the starting point is that if you say, well, no one pays a service charge, or with many of the other paragraphs to Schedule 8, the qualifying tenant doesn't pay a service charge, then you immediately have a breakdown in the way that the system works. And because you have a breakdown, you have someone who is left holding the baby. They've got the obligation, but they've not got the income to do it. And that's fairly crude, but that's the way it works. And if that's unfair, then the Act itself provides a means for shifting that obligation around. And taking this slightly out of order, I probably should have referred this to you when I was talking about the difference between paragraph 2 and the other paragraphs of Schedule 8 and the definition of a qualifying leaseholder. You have already been taken to section 119, which is in the core authorities bundle, tab 4, page 18. And I know points were made, well, it has to be a long lease, it has to be their home, or they have to run them two. You're not a qualifying leaseholder if you you're not the lease doesn't oblige you to pay a service charge, so that we're immediately talking about service charges. But if we look at subsection 3, which again, I'm sorry if someone has taken you to, but I don't remember this being mentioned.
So we're in section
119,
Thank you.
page 18. If you've got a series of, as it were, successive or superior tenants or landlords who might be qualifying leaseholders, it's only the one at the bottom that counts as a qualifying leaseholder. And that means it's only the one at the bottom that takes the benefit of the most of the leaseholder protections in Schedule 8. And you can imagine all sorts of different leasehold structures where the losses would lie in different places. So if you've got a multi sort of level title structure, and a qualifying leaseholder at the bottom would be liable to pay a service charge, for some reason he isn't, but the obligation to repair lies on its immediate landlord, well then that's where the buck stops. It's got no income, it's got the obligation. That's how it works. If it's an estate management company, well then that's where the buck stops. If there are sort of the qualifying leaseholder is sort of further up, then that's where the buck stops. So how is this fair? This seems a bit arbitrary, it's a bit random. And it's at that point that you have two sort of associated remedies, and they have to be considered in tandem. And they are the LPI regulations in section 124. You've been taken to the LPI regulations already. They're in the core bundle, page 82, behind tab 6. And it is right that they only apply as between landlords. So if you're the unfortunate landlord with whom the buck stops, this is one of the ways in which you can try and help yourself. And it depends why the buck stops with you. Why you are the unfortunate party who has the obligation, but who doesn't have the income. And Regulation 3 which is really the one engaged in this case, insofar as it's engaged at all, applies when paragraph 2 applies. So if you are the unfortunate party who is left with a liability that it can't fund from service charges, you can use Regulation 3 to make the responsible landlord, who's the person above you who's caused the problem, pay the remediation amount, which is the cost of remediating the problem. You are in this position because they are responsible. They are the developer. Well, you can serve a notice and get them to pay. If but-for condition is satisfied. If it's the contribution condition, so this would be paragraph 3 of Schedule 8, it's different. That's Regulation 4. That's at page 95. And nothing turns on this, but it's another way. So the contribution condition is engaged. We can look at it. It's just to sort of show you the way it works. Contribution condition is at page 69.
Sorry, I'm working from an unnumbered one. So
I'm sorry.
Oh,
So we're behind tab 4.
sorry, I've got a loose copy. It doesn't come from tab 4. So
I see.
Where in the regulations should I be?
So it's Schedule 8, Regulation...
Well, Schedule 8. Yes.
Schedule 8, Regulation 3.
Yes.
Para 3.
Sorry, Para 3, yeah.
Yes.
And so here you have... This situation applies where you have a qualifying lease. So you're now talking about the person at the bottom. If the landlord under the lease at the qualifying time meets the contribution condition. Now, there's a formula and it can get complicated, but broadly speaking, if they're a member of a corporate group with sufficient assets, then the qualifying tenant doesn't pay the service charge, which is the person at the bottom. And so again, you have, well, what can you do there? Well, you go to Regulation 4 at page 95. If you are, for some reason, the unfortunate landlord who's left holding the exposed because this service charge isn't being paid, you can serve a notice, and the landlord that has the money, that has made the qualifying condition, the contribution condition, apply, can be made to pay. So you can see there's a shifting of liability around landlords. And then over the page of Regulation 5, so this is page 98, but it's Regulation 5 of the LPI regulations, if they're loose. This applies when any of the other leaseholder protections apply. And there it's shared amongst the landlords in the title structure. And there's a formula, depending on your interest in the building and so on, it's different proportions. But the idea is to share the liabilities. When it's not your fault that the service charge doesn't kick in because you're so rich as a corporate structure, or when it's not your fault because you are the developer or associated with the developer, well then we're going to share the pain. That's the first way. And the second way is section 124, which we've looked at many times already in this case. And here your targets are somewhat broader, in the sense that you can go after landlords, but you can go after developers, even if they are not the landlord. And in that way, in my submission, the costs are either pushed to the people who have the deepest pockets, or the people whose fault it was. And that makes sense for at least two reasons. One, it just seems fair. Someone's got to pay. Well, it's your fault, you can pay. The second practical reason is that that someone, that developer, is likely to have all the material to bring a claim under the DPA or under whatever warranties he has and so on, and it will have the warranties if they are still worth anything. It makes sense for the developer to bring those claims. You know, the idea that sort of stray landlords in the title structure who weren't involved in the development of the scheme should bring DPA claims, well, it's very optimistic. Sorry, I've just looked at the time. I'm running way behind schedule, but I hope this is useful. So the final thing, and then I will scoot straight on to ground 1.9. The final thing that I would just like to point out is section 119. No, it's not section 119, it's done that. It is...
When you said fault, we heard some submissions that this section 124 is not a fault.
Sorry, yes, I don't mean fault in the strict. I
you don't mean legal liability. You mean that they did the development, so it's their responsibility.
Yes. Yes. So, sorry, the final point I would just like to make in relation to all this. If you look at paragraph 9 schedule, which is a paragraph you've been taken to in the context of the Adriatic appeal. And there's a limited amount of use I can get from this because I'm about to take you to a provision that has been inserted by Loughborough. But again, I don't think it's a provision you've been referred to, which is section 1A. So one of the problems with paragraph 9 is that if you can't charge a service charge for the costs relating to the liability of someone in relation to a relevant defect and so on, you can't raise the money to fight a contractor or a developer, or you just can't do it. So it's all very well giving us these remedies, but there's nothing you can do. You can't fund it. So the interesting thing in my submission about 9 subsection 1A is that management companies, so companies like EVML, can raise a service charge for going for a RCO. The general prohibition on legal costs remains if we're trying to raise the costs of going under the DPA or some kind of contractual warranty. We can't do that. And that, in my submission, is another reason why you can infer that if the scheme contemplates that it's the developer that will pursue those remedies. Having said that, I'm now going to jump straight to ground 1.9. I adopt my learned friend submissions about the other grounds. So we're in the supplemental bundle, which GFA is supplemental bundle section E, tab 3, page 192. And I'm going to give you a whole series of reasons why this is not a happily drafted document. But as a flavour or a starter for 10.
Which is alarming considering it's probably a standard document.
It is. It's a standard form. It's a standard form. If you look at paragraph 3.6.1. Well, before we go there, let's just look. It's at 192. It's dated the 1st of June 2003. So we're almost a full year after the BSA came into force. And now let's look at 3.6.1 at page 215. And this is a provision whereby...
Sorry, which paragraph again?
3.6.1,
Thank you.
page 215. This is a provision whereby various warranties are made on behalf of EVML. One of the things is that all the documents that we've given them during the course of the application process are true. And they say, provided that where any information or self-certification relates to the applicant's ability to recover monies from a leaseholder that is a protected leaseholder. I'll come on to what that means, but for now, it just means a qualified leaseholder, someone who has the benefit of all the other provisions of Schedule 8, and becomes, it's not has become, becomes, this has yet to happen. A year after the event, this has yet to happen. Misleading, then that won't be a breach of this undertaking or warranty that it's all still true. So then we have to look at the two provisions. And there are two provisions, because there are two provisions in fundamental conflict here. There's the provision at page 218. And there's the provision at page 223. And the provision at page 218 says you won't claim the cost of any qualifying expenditure funded by the funding. And your recompense for any that's paid. So if you've received it, you have to give it back. But if we look at 223, if you receive it, we have to give it to the dealer. Can't both be right. And you can't be liable both ways, having only received it once. So it doesn't work. And once you get to the point that it doesn't work, I'm now going to, I say two things about this agreement. And if we go to the definition of leaseholder in page 204, I'm going to put my arguments in two ways. So the first way is that the definition of leaseholder at page 204 is just mistaken. It's a mistake. They don't mean the bit about control. They probably don't even mean the bit about party to a lease document, because that potentially includes a freeholder as a party to a lease document. And my client...
That is realistic, is it? I mean, you mean a freeholder other than the person granting the lease?
Well, it could be that. I mean, and the problem is a lease document, if you look above, means a lease, if you're a party to the lease. So you're already saying, well, it can't quite mean what it says. We have to take something of a red pen to it. EVML's a party to all the leases, the tripartite leases as an estate management company. Surprising if we're leaseholders. So that's the first submission, and I'm going to go through all there aren't very many of them, but the various places in which the word leaseholder features, and I'll explain why that supports that submission. The alternative is that we say that if and insofar as there's a conflict, and there is a conflict, there's a plain conflict between the two provisions, the obligation at 4.3.1 doesn't carry the day. It must mean going after a tenant, or even a leaseholder, using this expansive definition, qua leaseholder, qua some nexus relating to a tenant, using a landlord and tenant remedy, rather than going at someone who happens to fall within that definition as developer or associate as developer, using a completely different remedy.
So what would be a remedy qua leaseholder?
Well, the obvious one is service charge.
Well, I thought you'd had that in mind. Does that exhaust your concept?
Well, so one of the other ways that a landlord often goes against a tenant is that this is the Hallsall and Brazil jurisdiction. So this is where,
yes,
well, it might be difficult to see how that will feature in a cladding case, But that is, for example, another remedy that a landlord might potentially have against a tenant, arising out of the landlord and tenant relationship.
But primarily you're focusing on the service charge.
Yes,
remedy.
or damages. You know, damages is a remedy. No,
Under a covenant in the...
under a covenant in the lease.
Just while you're there,
Yes.
4.3.1 provides for leaseholders to enforce.
Yes.
But the undertaking is to the department and GLA.
Yes.
And I can't remember any learning on this. Can the department and GLA waive the clause even though leaseholders can enforce it?
There are restrictions. There are restrictions, and they're to be found in the 1999 Act.
Yes.
So I have to accept, and I apologise, my skeleton argument overstated the position. And at least one of those restrictions is that it can't be waived, as it were, by the contracting parties, or varied by the contracting parties, if a third party with the benefit of it has relied on it. So there's an issue there. But of course, I say if Get Living isn't a leaseholder, then we're not even there.
Then I follow there isn't a problem, but
Yes,
waiver might not be a solution.
might not be a solution. So, I'm going to take this quickly because otherwise it will become extremely boring, quite frankly. But if we look at page 204 at the bottom, we have the definition of leaseholder's contribution. Which means a service charge provision. Required toward the cost of the works from the relevant leaseholder's lease, except that where the leaseholder is a protected leaseholder, which is a qualifying leaseholder, you can see that over the page, or a couple of pages on at page 207. So, in my submission, the definition of leaseholder's contribution sort of bakes in the idea that we're talking about a tenant. Protected leaseholder at 207, page 207, I do notice leaseholder is not capitalised. So maybe they do mean genuine leaseholder there as opposed to this expanded definition, or maybe that's a typo. At page 215, I've already taken you to this. It might be that this turns on the definition of protected leaseholder, and so we don't need to worry. At 216, at clause 4.2e2, we have a provision dealing with how EVML is to receive the money.
Sorry, 4.2.
E Roman 2.
Yeah.
Sorry, 4.21 E
Yes.
Roman 2. So we can see it's part of the machinery for receiving the money, and we have to specify how the money is going to be received. The client money protection scheme, that's to do with managing agents. They have to be a member of a scheme whereby client money is safe. But the alternative, details of a separate legal trust established and maintained by the funding recipient for the benefit of the leaseholders. Well, that's a Section 42 trust. That's consistent with the money being given for the benefit of the tenants who would pay the service charge. That's not consistent with control. And some distant party that just happens to have majority voting rights over a tenant. Over the page at page 218, we've looked at D. I will come back to D, but there are various other provisions that it is worth noting, and the one I'm going to start with is F. in its service charge accounts for each leaseholder. So leaseholders will be someone who have a service charge account. That leaseholder's contribution. So that's the amount that they would be liable to pay. I'll talk you to the definition of that. Irrespective of the funding amount, and noting that where the leaseholder is a protected leaseholder, the figure may be zero. So what you do, you receive this money in, and you have to say, well, this chap has a liability to pay £10,000, say, because they're not a, that's a bad example because that's the cap, but £1,500, because they're not in any way protected. I'm going to allocate £1,500 of this money to that leaseholder's service charge account. And there's no sort of any leaseholder that happens to be your tenant and has a service charge account. The leaseholders, the assumption is they will have a service charge account. And that is a convenient point to go back to D and note that the requirement to repay would include, for example, repaying into a sinking fund. Well, that assumes that they're the tenant. The sinking fund is held from, on trust for the tenants from time to time for the purposes of the matters for which it was collected. G, only raise a service charge payment from a leaseholder if it's non-qualifying. Now, I do accept that in response to this, you might say, but that's just a leaseholder. Now, some of the leaseholders will fall within that and some won't. So it's not as definitive as F. But it's still indicative of this idea that the leaseholder is the party obliged to pay a service charge. And then you've got H. If a leaseholder has paid a service charge contribution, which is subsequently refinanced, the applicant will notify each leaseholder and reimburse each leaseholder. So again, the assumption is that it's someone who might have paid a service charge. And that doesn't fit with this expanded idea of control. And then you've got I. I'm beginning to, as it were, sort of go down in substance, but you can see that the theme remains the same. I is to notify the leaseholders as to the financial treatment. Now, this is particularly relevant because you will probably remember after Grenfell that leaseholders were being clobbered served with very significant service charge demands. And it was distressing, right? People were trapped in their homes. It was extremely distressing. Also, there's an obligation to keep them informed. I don't see why that matters if the leaseholder is just someone who's in control somewhere remote. And then there are a series of provisions which probably don't assist one way or the other, but are at least consistent with the leaseholder being, as it were, the individual who's primarily affected. So you have at page 230, clause 10. And there's an obligation not to talk to the media without first notifying the GLA and DLUC, but that doesn't include the leaseholders. That's at least consistent in my submission with the individuals at the bottom, right, who have the genuine sort of public interest stories to tell the media. 231, clause 12. Not to harm DLUC or the GLA's reputation. Again, doesn't include leaseholders. And in my submission, again, that's consistent that it's really, we're trying to excuse or exclude from this obligation the sort of the individuals at the bottom. You can get the gist. Page 233, paragraph 13.1.3e. Sorry, 232. 13.1.3e. Keep leaseholders informed. Leaseholders in the building. 234. Comply with data protection provisions. Ensure we're permitted to preserve the data protection of leaseholders.
Sorry, where are you?
Sorry, page 234, clause 14.2.
I see. So the fundamental problem is the definition of leaseholder.
Yes, and that's the first. When I said I have two submissions to make, the first submission is that if you look at the GFA as a whole, this expanded definition of leaseholder just doesn't fit. It just doesn't fit. I don't know why it's there, but in my submission it's an obvious mistake, and we're in classic correction of mistake by construction territory. We say what it does mean is tenant liable to pay a service charge. Yeah, that's what all of this is about. If I'm wrong about that, then I have my secondary submission, which is that where you have these two provisions in conflict, the obligation to recover and repay the building safety fund trumps the obligation not to go after a developer just because they happen to control the tenant. And I say you can construe it like that because the context of this GFA is the policy of the Act, which I have explained, which encourages parties to go after developers.
I thought you had a slightly different submission, maybe part of the first one, which is that the clause which causes you the problem, which is 4.3.9,
Yes.
only applies to claiming the cost qua service
Yes.
charge.
Yes. So I mean, maybe this is a third point, right? It's a three ways.
Well, that doesn't depend upon how broad the potential pool of leaseholders is.
No, it doesn't.
It's
doesn't.
just that it's only when you're qua landlord going against someone qua tenant
Yes.
that 4.3.1d is engaged.
Yes. So I'm sorry, my lord, you're absolutely right. So there are three submissions. There's the expansive one about the meaning of leaseholder. There's a slightly less expansive one about clause 4.3.1, qua tenant as opposed to developer or someone associated with a developer. And then there's just the sort of the third string that you've got two provisions that conflict. And in the context of this GFA, which includes the Act, you can prefer the obligation to go after the developer and pay the and pay back the building safety fund. Now, it might be that there is little to be gained by this, and I'm afraid I'm about to highlight a document that isn't in the bundle, and so I'm going to have to say that we will get it to you. But what I can say is that it was before the FTT, and it was in Bundle J. It was document 156, and it was the guidance for the Building Safety Fund at the time this particular funding was advanced. And I will make sure it's with you overnight. But we say two things. The first is that the guidance said that the GFA requires applicants to take reasonable steps to recover remediation costs from a prior building owner, a developer, or a cladding installer.
This is guidance issued by.
Guidance issued by the GLA and DLUC itself. It's the guidance for the scheme
Yes, okay.
that we applied to and led to this GFA.
So what page in J1?
That's J156. And the bit that I quoted was on page 11, footnote 9. And at page 6, there is also a heading titled Funding Guidance or Objectives. And this is one of the objectives. It's not the first, but it's one of them. Cost recovery from those responsible. Sorry? Right. I'm told by my learned friend, Mr. Nissen, that although we don't have the document, that is in fact quoted in the judgment. I must have missed that. I apologise.
Well, they didn't quote it.
Oh, they refer to it. And I just, I mean, maybe these are jury points, but we just have to think through the consequences if my learned friend's submission is right. Any developer, any contractor, any architect, any fire engineer, any designer will just buy a flat in the building. If that is right, then the party to the grant funding agreement is precluded from seeking an RCO. It doesn't say RCO, it says claim. Pursuing them under the DPA, pursuing them under the warranty, doing anything.
Can we just think through that one moment?
Yes,
So you say a developer buys a flat in the building.
yes,
At that point, they become a leaseholder,
yes,
but they definitely do.
yes.
So is it your earlier solution about the definition of leaseholder probably doesn't
Well, it might be
not
that I
do
need,
it. My lord's third possibility might suit you better.
Yes, it might be that I need several strings, but this doesn't work as a GFA. It doesn't work, and there are various ways one can deal with it. And my lord is absolutely right that you are right. If a developer were just to buy a flat in the building, which means I would need one and two or three. Or maybe just two or three would do. But that would be a very surprising result
It would be a surprising result.
in the context of BSA and so on.
Well, you might find with developments that the developer has actually retained some common parts, estate roads or whatever, under a lease.
Well, that's not unusual.
Exactly.
That is not unusual. Yes. Yes.
And it would be slightly surprising is because they've got a lease of the common parts. Nothing artificial about it, it's just
Yes.
just happened to have. You couldn't sue them for an RCO at all.
Yes. Yes, someone behind me is whispering very loudly the roof space. That's not unusual.
Yeah.
So, my lord, those are my submissions on ground 1.9. And I'm just going to make, if I may, and I'm trespassing on my learned friend Mr. Walsh's time, just a couple, if I may, observations about ground 2. Now, I said at the start that ground 2 doesn't really affect EVML, and it doesn't. But I have to say that with my EVML hat on, I was alarmed to hear my learned friend Mr. Loveday suggest that the effect of Schedule 8 is that you can undo transactions going back whenever. The fire door issue in 2006 doesn't affect us because the buildings weren't up at that yet. But say the fire door issue in 2016, it is one thing, well, it would be a major problem for EVML if the effect of Schedule 8 is that we had to start recalculating service charge provisions going back howsoever many years that had been paid, the transactions closed, the books closed, because we don't have the money to deal with that. And that, in my submission, is a practical reason, at the very least, for payable. Payable meaning, well, what matters is whether it was outstanding when the Act came into force or since, or not. Because then at
A
least...
demand having been served. In what sense are you using payable?
In my submission, that must mean contingent. So yes, I suppose it must mean a demand having been served.
Sorry.
A demand having been served.
I'm going to write it down. So just give me again what you think the position is.
Payable means we could sue for it, and that requires a demand to serve.
Sorry, now I'm completely confused.
Sorry. So
there doesn't seem to be any doubt.
yes.
That under paragraph 8, when it says no service charge is payable for certain things,
Yes.
if the costs are incurred after the 28th of June,
Yes.
and the service charge would otherwise fall due after the 28th of June, you can't
Yes.
recover it.
Yes. Agreed.
Everybody accepts that. So
Yes.
nobody disputes the prospective effect. The
But if
debate is,
Yes.
does it only mean that, which is Mr. Allison's position, or does it mean, which is Sir James's position, if you haven't paid it before 28th of June, you don't have to pay it even if the costs were incurred before 28th of June, and even if a service charge bill had gone out, as long as the leaseholder hasn't paid, he gets the protection. That
Yes.
was what I understood Sir James's position to be. Or does it mean, which was Mr. Loveday's position, it doesn't matter whether you've paid it before the 28th of June, you can still recover it?
No. So our position is as set out in paragraph 76 of our skeleton argument, and it dovetails in with the outcome of the Upper Tribunal in Adriatic land. We say that I align myself with Sir James on Adriatic land.
That's what I thought.
Yes, if it hasn't been paid, then it ceases to be payable,
Regardless of the fact the costs.
regardless of the fact that the costs have been incurred and demanded and so on and so on.
Yeah.
And that provides, that resolves the problem that my learned friend Mr. Loveday's submission, the practical problem, the real world practical problem that would cause a company like my client. Our position is also that section 124 can apply back to costs incurred prior to 28th of June 2022, because it doesn't suffer from the same problem. And I know my learned friend said, well, the safety release valve, the pressure release valve, it's imaginary, it's not really there, it doesn't count for anything, but it would count for something. There's the world of difference between someone coming to my client and saying, aha, fire doors in 2016, you have to recalculate the accounts and either give me a credit or reimburse me and so on. Or coming to me and saying, aha, fire doors in 2016, I shouldn't have paid the service charge. I'm going for an RCO to get it back because I'm entitled to say it's not just an equitable this far down the line. I've lost all the documents. I have no corporate memory of what even the issue was anymore. Or, thank you very much, I am going to join someone else. I'm going to join SVDP into the same RCO proceedings, and it can all be sort of fought out in the round. And that is far less problematic for a company like EVML than the suggestion that it all just happens automatically pursuant to Schedule 8 without any tribunal involvement.
And indeed, so far as paragraph 2 of Schedule 8 is concerned,
Yes.
Mr. Loveday is right. All the leaseholders, whether they're qualifying leaseholders or not,
Yes.
can get back anything that they've spent on fire doors or anything else, because you've got a developer in your chain.
In principle, yes. That can't be right. And I commend to your lordships my own friend Mr. Nissen's point which is that it's necessary for 124 to have that retrospective effect, because otherwise you have this anomaly that tenants, the conscientious tenants, or maybe the tenants that were just misfortunate enough to be able to afford the service charge, that they shouldn't have paid, we now say they shouldn't have paid and wasn't their fault, are prejudiced because they're not protected by Schedule 8, and unless Section 124 is retrospective, they're not protected by Section 124 either. And that cannot be right, because in those 5 years, it's a long period between June 2017 and June 2022, there was a lot of money being spent. I mean, my learned friend Mr. Nissen made this point. He made it in relation to waking watches. But it's not just waking watches and installation of, some buildings were remediated. The ACM cladding, I mean, there was a massive push to get that down as quickly as possible, almost before decisions were being taken as to what goes up in its head. So it's I mean, ultimately, the statute means what it says, and if it's unfair, it's unfair. But in my submission, I'm going to leave the A1P1 human rightsy points to the public lawyers, but in my submission, there's an obvious defect in the Act as a comprehensive scheme, which it plainly is, unless at the very least Section 124 can go back, look back to events before 28th of June, and rearrange liabilities prospectively based on that. It is, as my learned friend Mr. Nissen has said, a relatively benign form of retrospectivity. On the sliding scale, it's the least objectionable. So, my lords, I'm sorry I've run over, but unless I can be of any further assistance, those are my submissions.
Thank you very much, Mr. Polly. Mr. Walsh.
Thank you, my lords. The Secretary of State, as you know, only intervenes on ground 2, and as the court will be aware, the issue on ground 2 is whether costs incurred before Section 124 came into force on the 28th of June 2022 are recoverable under a remediation contribution order or an RCO. I don't intend, you'll be relieved to hear, to repeat what has been said, and I will be as economical as I can. But I may cover some of the same ground to emphasise points where those arguments are particularly important from the Secretary of State's perspective for the wider operation of the BSA. The court has also heard extensive argument earlier this week from the parties on the Adriatic appeal, and Sir James, on behalf of the Secretary of State, set out the broad policy objectives of the BSA, and I adopt those submissions on this appeal. Section B of the Secretary of State's skeleton argument in Adriatic, which for your reference is Adriatic Core Bundle, page 105, sets out the detailed background as to why the BSA was enacted by Parliament following the Grenfell fire and indeed other fires in high-rise buildings. So I will leave that and adopt that in my submissions. The safety of those living in buildings with fire safety risks is of paramount importance to the Secretary of State. The proper and effective operation of the Building Safety Act is central to that mission. As Sir James said on behalf of the Secretary of State in Adriatic on Tuesday, the key justification for the BSA was to allow recovery of costs for remediation by those responsible and remove it from the shoulders of leaseholders. As Mr. Murphy says in his witness statement at paragraph 98, it is an equitable redistribution. That's an Adriatic additional bundle, page 111.
Sorry, I didn't catch the paragraph reference. Paragraph
98.
Yeah. In summary, the Secretary of State's position is that an RCO can be made in respect of costs incurred before Section 124 came into force on the 28th of June 2022 for three main reasons. First, the overall purpose of the BSA and associated subordinate legislation is to protect leaseholders from paying for remediation insofar as possible, and to make those responsible for the defects pay for those costs instead. Retrospectivity is fundamental to this overarching aim. Second, that an RCO can be made for pre-commencement costs is obvious on a plain interpretation of the words used in the statute. And third, it is also obvious by considering that interpretation against the general scheme of the BSA and related sections in Part 5 and Schedule 8. I note in his submissions yesterday that my learned friend Mr. Selby accepted that one of the purposes was to ensure that leaseholders are not required to shoulder the costs of the remediation works. And I'll develop this in more detail in due course, but that aim would not be achieved if it did not apply to costs incurred before the 28th of June 2022. It's not the proper construction of Section 124 when considering the words used and the overall objectives of Part 5 and Schedule 8, that those leaseholders who paid for remediation pre-commencement should be left to complex litigation under the DPA, or indeed under Section 149. And in that regard, I adopt my learned friend Mr. Nissen's submissions on that point, although I may develop some of those later in my own submissions. What I want to do, my lords, is just to develop some of the general scheme of Part 5 and Schedule 8 without traversing ground that we have covered already. And to take you to how the various provisions hang together to advance the policy objectives outlined in Adriatic. And I'll then deal with Section 124 specifically and the FTT's, we say, correct treatment of it. And I'll also deal with some of the arguments that have arisen on the appeals. Firstly, the law. Your lordships have heard a great deal about the law, and there is also a great deal in the skeleton arguments on both appeals about the law, and you have heard the important principles recited by others, but I do want to just make a few brief points, if I may. The FTT set out the law in its decision in relation to aids to statutory interpretation at paragraphs 50 to 56. That's Triathlon Core Bundle 161. And in relation to retrospectivity at 55 to 69, that's Triathlon Core Bundle 162 to 164. The court, of course, should identify the intention of Parliament from the natural and ordinary meaning of the words in their statutory context and the consequences of different interpretations, and that is set out in Quinta Vale by Lord Bingham at paragraph 8. Your lordships will find that in Adriatic Authorities Bundle, page 548. I think in light of the time, I might just leave your lordships with the reference to that and not take you to it. Benyon has also been referred to in the course of the Appellants oral argument. That was at Core Authorities Bundle, page 428. And it deals there with legislation that interferes with proprietary rights. There it says legislation will be construed as interfering with those rights, no more than the statutory language and purpose require. So the purpose of the legislation must be borne in mind when interpreting the statute. And that was an observation made earlier in the course of argument by my Lord Justice Holgate. The distinction between legislation that affects matters in the past and which provide for the future consequences of past offence is a question of degree, and that's set out in Benyon at paragraph 7.13, Core Authorities Bundle 342, and you've already been taken to this. Again, I don't intend to turn it up. In that extract, if I can just say for your lordship's note, I draw attention to the AXA case and the dictum of Lord Reid in the AXA case, which again you were taken to earlier in the week. I would also invite your lordships to look at the extract from Craze in the Authorities Bundle, Adriatic Authorities Bundle 2371. The extract starts at 2366, but the important part is at 2371. Again, containing a more detailed analysis of the brief summary that I've just given of the principles of interpretation and retrospectivity. But where the court is interpreting retrospectivity of legislation, the test is one of fairness, and indeed that was set out in the Sharifian case. That is in Adriatic Authorities Core Bundle at page 333. If I could ask your lordships to turn that up. Or perhaps it's easier if I read it, given it's a short extract from the headnote.
I will just find it.
At page 333 of the Adriatic Authorities Bundle.
Oh, actually, I haven't got the Adriatic Authorities Bundle here, so I won't read it. Yes.
Well, shall I read it, my lord?
Yes,
please. It was in the headnote, held allowing the appeal that the basis of the rule regarding retrospectivity was fairness. Again, a principle that's been put to your lordships already. That the rule was not absolute, and the question in each case was whether the consequences of reading the statute with the suggested degree of retrospectivity were so unfair that Parliament could not have intended its words to be so construed. And that's the fundamental principle at play here.
Up to a point.
Up to a point.
There is a presumption. And you had that extract from Lord Mustill, but this is worked through in other authorities, in particular Lord Roger and Wilson, which we haven't looked at. I noticed earlier on that your lordship indicated a concern that perhaps these authorities hadn't been traversed in as much detail as you would have preferred. I wonder whether it might be an idea if overnight we prepare a short note, or if I deal with it in our right of reply over the course of the two appeals, and just take your lordships through and give you references for all of the cases. Would that be a more convenient? I think that would be
useful.
And plainly, the Lord Mustill passage is of great importance.
Yes.
But I do have this worry that it doesn't stand on its own. As you say, we've been taken at some point to the bit from AXA, which is of wider relevance, but I think Lord Reid was really dealing with A1P1, wasn't he, primarily? But you do find more learning running through the cases.
You do, and the skeleton argument of the Secretary of State in Adriatic deals with the law in the context, of course, of Schedule 8.
Yes.
But what I think might be useful is if I just draw the strands together
Yes.
in one composite note, a short note, so that your lordships have them.
Yes.
And if there's any oral submissions to make, perhaps I can do that, but perhaps better just leave it to a short note.
Yes.
Well, I will leave the law on retrospectivity and interpretation there. Turning then to the scheme of Part 5, the FTT gave a brief summary of each of the relevant parts of the BSA in paragraph 17 to 43 of its decision. That's Triathlon Core Bundle 154 to 159, which the Secretary of State respectfully agrees with and says ought to be adopted by this court as a correct summary of the legislative provisions. As the court knows, LAFRA has made some amendments to the provisions of Part 5 relevant to this appeal, and that is since the decision. I'll mention those a bit later on, but I adopt Mr. Nissen's submissions on that point. And I also refer to our own skeleton argument, which I'll come to in due course. But that really deals with the point that it doesn't support the appellant's argument that the amendments were in some way showing the deficiency of the retrospectivity of Section 124 and other parts of Schedule 8. We set out in our skeleton argument a a summary of what each of the parts do. I'm not going to repeat that now, again, because of the time. But some parts of the BSA are forward-looking. So, for example, in Part 4 relating to building regulations. Part 5 is, for the most part, backward-looking. It is concerned with remediating defects created in the past, and that's reiterated by the explanatory notes at paragraph 957 at Core Authorities Bundle at page 385. I'll come back to explanatory notes in a moment, but I just put a flag in that for the time being. Part 5 implements several mechanisms that are intended to achieve the central aim of remedying these historical safety defects. And it's clear from the FTT's explanation of the interaction between Part 5, Schedule 8, and the Building Safety Leaseholder Protection Information Regulations 2022, or the LPI regulations as they've been referred to in the course of the appeal, in their decision at paragraphs 39 to 43, Triathlon Core Bundle 158 to 159, that the scheme of the BSA and its subordinate legislation is there to ensure multiple ways to recover costs depending on the circumstances. And those provisions are torrential, to borrow a phrase from Mr. Polly's skeleton argument on a slightly different point. But I would just pause there to also refer your lordships to my own friend Mr. Polly's submissions on the LPI regulations, just to demonstrate the very torrential nature of the provisions, how there are multiple ways of recovering from one party or another depending on your position in the hierarchical structure of either the title or indeed the responsibility structure, if I can put it that way. I turn then to some key sections of the Act in Part 5. And I, again, don't intend to go to these. You've been taken to each of them, I think, now at least once. But I will just alight upon each and highlight some of the more important parts. We start at section 116, which you were taken to, I think, yesterday, at least for the first time, Core Authorities Bundle, page 14. That introduces sections of Part 5 that deal with remediation of certain defects. And you can see from those provisions that sections 117 to 124 and Schedule 8 are the operative sections. And that section shows that there are a number of sections that create a self-contained code for dealing with remediation. And they are set apart, as I'll come to in a moment, from some of the other sections that are in Part 5. Specifically one section 135, 148, 149, 150. But those sections that are contained within section 116 introduce that scheme of remediation of certain defects. Section 117 defines the meaning of relevant building. We don't need to go to that. Section 120 gives you the meaning of relevant defect and relevant steps with the Laffer Amendment. Again, we don't need to turn this up because Mr. Nissan has already taken you to this afternoon. But what I, like he, would do is lay emphasis on that 30-year period ending with the time that this section comes into force. So it is dealing with relevant defects from 1992 all the way through to 2022. Turning then to the explanatory notes, I adopt the submissions of Sir James made on behalf of the Secretary of State in Adriatic in relation to their weight. I'm not going to trouble your lordships any further with any argument on that. I respectfully say that Sir James's analysis is correct. The Core Authorities Bundle, page 385, contains the explanatory note for section 120 of the Act, and there we can see setting out that it is dealing with historical safety defects, backward looking only. They are a one-off intervention designed to deal with the current serious problem with historical building safety defects in medium and high-rise buildings. And it goes on, making...
Actually, I think I'm looking in the wrong place. Which paragraph should I be in?
Sorry, 957.
Oh, I see, yes.
Which is at page 385. I do apologise.
Yes.
The next important section is section 122. That gives effect to Schedule 8. And as we're in the explanatory notes, if I can ask your lordships to go to 390, because we've been to the section giving effect. Section, paragraph 985 deals with the removal of the legal presumption under most leases that leaseholders are liable in full for the costs associated with remediating relevant defects. Deals with the permitted maximum. And then 986 deals with the question no service charge is payable. I'll come to Schedule 8 in more detail in a moment. And then halfway through that paragraph is the important point that I want to lay emphasis on, and that is this means that even if a valid service charge demand was issued prior to commencement, provided that the service charge had not already been paid by the leaseholder, the demand is no longer valid after commencement insofar as it does not comply with the provisions set out in the schedule. And then it goes on to say more about what they will have to do with those demands, and then in the final sentence, where landlords are entitled to recover some costs from leaseholders, according to the schedule, they will need to issue new service charge demands which comply with the provisions set out in the schedule. So, making it clear, which is a point I'll come to in a moment, that if service charge demands have been made post-commencement, then they are no longer valid if they are unpaid. Again, that's a point I'll develop more in due course. So those are the self-contained code, as I've called it, and I'll come to section 124 in some detail in a moment once I've finished with the remaining sections. Section 133 makes a series of amendments to the Landlord and Tenant Act 1985 to make sure that landlords take reasonable steps to recover the costs of remediation works from third parties before passing those on to leaseholders, but that is not yet in force. Section 134, a well-thumbed section over the course of these two appeals, as well as Section 135. Section 134 creates a new cause of action under the DPA. And Mr. Nissen referred to the effect of that during the course of his submission, so I won't develop that point any further. Section 135, of course, inserts a new provision into the Limitation Act, extending the limitation period from 15 to 30 years, to 30 years by amendment. And then my own friend Mr. Selby referred you to sections 148 and 149. 148 creates a new cause of action where a construction product used in construction works causes or is a factor in causing a dwelling to be unfit for habitation on completion of those works. That is prospective. There's nothing retrospective about that provision. And section 149, Core Authorities Bundle, page 57, creates a new standalone cause of action. Unlike section 148, it is retrospective. So the two sections use precise language to distinguish what is retrospective and what is not retrospective. And you can see that contrast if you look at section 1482 and 1492 together. Condition A in 1482, condition A is that at any time after the coming in force of this section, section 1492, condition A is that any time before the coming into force of this section. I'll perhaps deal with this in a bit more detail later on, in relation to the language and contrasting it. But it might be convenient just to deal with it now. But this does use more precise language because these two sections, one is retrospective, the other is not. It is only prospective. And section 124 is part of that unified code and does not need to use those additional words in order to convey that it is fully retrospective to events that have happened in the past. If you look at section 135, which deals with the extension of the limitation period, that is, of course, amending a pre-existing course of action, not a new course of action, a pre-existing one. And, of course, very clear words were used in order to make it clear that it was retrospective. Now, I'm going to come to section 124 shortly, but before I do, I just want to briefly address how Part 5 and Schedule 8 and the LPI regulations work together. I'm not going to address the LPI regulations in any great detail. My learned friend, Mr. Polly, has done, if I may say so, an admirable job of that task. But Part 5 and Schedule 8 together encompass a combination of remedies in order to advance the overarching policy objective of the Act. Schedule 8 is a shield for to leaseholders. Section 124 is an action that allows the recovery of sums spent on remediation. Both prospectively affect past events. So Section 124 and Schedule 8 work in tandem to ensure that leaseholders are protected. As you've heard, the most sweeping of all of those paragraphs in Schedule 8 is paragraph 2, which applies to all leaseholders, irrespective of whether it's a qualifying leaseholder or not. Schedule 8 prevents recovery of remediation costs through the service charge, other than in paragraph 2 if the leaseholder has a qualifying lease. And it is prospective in that it bars the right of recovery by the landlord of costs following commencement on the 28th of June 2022. So the proper construction of Schedule 8 is that if the service charge has been demanded but not paid after commencement, there is no right to recover those unpaid sums under Schedule 8. If a leaseholder has paid a demand made prior to commencement, it cannot recover the sums under Schedule 8. It must seek an RCO. This is why RCOs are a vital component of the leaseholder protections in Part 5 for the recovery of sums spent on remediation prior to the 28th of June 2022. Now, you've already looked at explanatory note 1012 in Core Authorities Bundle 393, which explains this is how Schedule 8 and Section 124 work together. Unless your lordships have it in your mind, don't have it in your mind, I won't turn it up. It is not, in my submission, possible to recover those sums under the provisions of paragraph 10.2b. And I accept this point crosses over into Adriatic territory, but it is relevant to the interplay between Section 124 and Schedule 8. So that is why I underscore what Sir James said on Tuesday. In my submission, paragraph 10.2b is intended to provide recovery for sums paid under prohibited demands after commencement. So assuming a leaseholder has a demand, doesn't realise anything, doesn't realise they have act rights under the BSA, and then simply pays it in the usual course, they have a right to recover that using the terms of Section 2b.
It's not retrospective.
I'm sorry?
It's not retrospective.
No, I say Schedule 8 doesn't allow clawback, if I can put it that way. It doesn't have a mechanism for clawback post-commencement. What it does is destroy the contractual right of recovery. Can I just offer your lordships an explanation of the consequences if you're against me on that? Because I detected in the Adriatic appeal some interest in the contrary construction. If you are against me on that point and you find that paragraph 10.2b is operative to allow clawback of sums paid prior to commencement, then you still need section 124 to be retrospective to allow recovery of sums spent prior to commencement in order to give effect to the overall concept and policy objective of the Act. And that's really, I can deal with this point fairly shortly because of the discussion earlier in the week about section 27A, so you know how it operates. But let us assume a group of tenants diligently take off their cladding and or indeed do any other works that would be remediating a relevant defect, to put it more generally. Post Grenfell, let's say 2018, 2019, they pay for it. It was a considerable sum of money to them as individuals. Of course, a small sum of money in the grand scheme of the remediation project. And they admitted that they owed those sums under their lease, or indeed that they went to the FTT and fought about it. And the FTT said, determined that it was payable under the terms of their lease, as indeed happened, I think, in some cases.
So just to be absolutely clear, when you say a group of tenants decide to do these things, you assume that the landlord of some nature has done them,
yes,
such that service charge is being
forgive me, let me be clearer. A landlord does the works and charges it through the service charge, but the tenants are found liable to pay it, or they admit it, and they pay it. If the construction of 10.2b is correct, it would be, in my submission, difficult, if not impossible, for those tenants to use section 27a as a gateway to reclaim those costs, because they would have been taken to have admitted, or a tribunal may have found that they were payable under their lease, thereby ousting the jurisdiction under section 27a when it comes to service charges. They would therefore need to seek an RCO in my submission. And again, the just and equitable test would apply as it would under any other RCO.
You're probably moving off this point, but while it's in my mind, you refer in your skeleton to the case, not in this context at all, where service charge accounts were reworked going back decades.
Yes.
So suppose that were the situation, then you just work through year by year by year to see where you are now, do you?
You might do. It is sometimes a long and excruciating accounting exercise, but it depends very much on the circumstances, the costs, and how the accounting has been done. I think the cases that your lordship has in mind are Kane and Islington and G&A Guerrara, which are referred to in our skeleton argument. I was going to come to that, but I may not.
Oh, I see. Yes.
And it may not be necessary, given that your lordship has the point from our skeleton. It is said that in certain circumstances, landlords might be saddled with irrecoverable costs if that construction of 124 and Schedule 8 is correct. Well, yes, maybe, but there are, to go to the fairness question about retrospectivity, a multitude of other routes by which that landlord can seek redress from others, or indeed assistance from others. Just very briefly, there is of course government funding. The government funding under the Building Safety Fund is known to your lordships through the submissions over both appeals. I'm not going to go into that in any greater detail. There is of course pre-tender support. In this case, of course, 2 million was awarded to EVML in pre-tender support, and my learned friend Mr. Holly had referred to that in his submissions. There is also, of course, the opportunity to seek an RCO, and then there is inter-landlord cost spreading under the LPI regulations, which again my learned friend Mr. Polly has traversed in some detail. But there is a package of measures available to landlords who are affected by the operation of sections 124 and Schedule 8, where it interferes with either a pre-existing right, contractual right, or it imposes what they regard as some sort of unfairness on them. It is not as if there is a binary outcome when landlords are unable to recover, for example, service charges under Schedule 8. It's not, I wouldn't even say it was binary, they just simply lose out, they have other routes of recovery. So then come to Section 124 itself, which is, as you know, at Core Authorities Bundle, page 30, and the pre-Laffer Amendment version is at page 89, depending on which one your Lordships have been working from. I'm not going to read anything from this. Just say to refer to subparagraph 2, remediation contribution order in relation to a relevant building means an order requiring a specified body, corporate or partnership to make payments to a specified person for the purpose of meeting costs incurred or to be incurred in remedying relevant defects. So the meaning of incurred or to be incurred, Mr. Selby urges a construction that means those words only apply to costs that are incurred or to be incurred post-commencement. That is not the correct construction in my submission. As the FTT decided at paragraph 73 of their determination at Triathlon Core Bundle 166, we are in no doubt that Section 124 allows remediation contribution orders to be made in respect of costs incurred before 28th of June 2022. And then continuing, the language appears to us to be clear and explicit, and the absence of any temporal limitation or transitional provision is telling. The Secretary of State respectfully agrees and says that the FTT was plainly right. The same construction on those words, incurred or to be incurred, applies in Schedule 8. It is inconceivable that Parliament could have intended different meanings. And so where it was said in Adriatic, and this is relevant to the Triathlon appeal, which is why I mention it, but where it was said in Adriatic by my learned friend Mr. Allison that the words incurred or to be incurred were imported or some way comparable to the definitions in the Landlord and Tenant Act 1985 or in the context of that act, and he prayed and aid Shulam B in relation to that. I say that is not correct. That is not the correct interpretation. The BSA selectively and deliberately imports some definitions from the LTA 1985 in paragraph 10, but it doesn't adopt them wholesale, and it certainly doesn't adopt anything in relation to those words. Incurred or to be incurred is to be given its ordinary and natural meaning. And as the FTT said, it is unlimited, it is without qualification, it is not qualified by any temporal restriction. As Sir James said on Tuesday, the same words are used in 124, and it would be a nonsense if those words bore the same meaning as in the LTA 1985, because of course Section 124 is not exclusively about costs incurred under service charges. Can I just then come to the importance of retrospectivity? I can wrap up in the next 5 or 10 minutes.
Now, we have to rise very promptly by 15:15. And you are in any event going to produce a note overnight.
Yes.
I just wonder whether we should leave your 5 or 10 minutes to the morning.
I'm yes, happy to do so, my lord. I could see where I get to in 5 minutes if you do want to rise promptly. Or I'm happy that is a convenient moment.
To one member of the court, perhaps it's better to stop now. And
of course.
We'll start again at 10:30, and obviously you won't have very far to go.
Not at all. Thank you very much.
My lords, I did, I think, volunteer to do some homework in relation to retrospectivity, but I see my learned friend has kindly volunteered that. So, unless your lordships separately wanted to hear from me, I'm inclined to respectfully anticipate what he says and likely endorse it.
My lord, can I
Mr. Polly.
It's my fault that the timetable's gone out of kilter.
I don't think we are really out of kilter, actually. If we are, we're out by 5 or 10 minutes, which I'm not going to complain about.
At least he didn't call you Mr. Tesla.